Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership.
Oh, they teleported. I can't hear anything all of a sudden. Oh, that's not it. Or did I just lose everything? No sound data.
I know I'm muted. I was saying a few choice words.
Oh, thank you. Okay, I was just like, why is my setup?
I don't know why. I did it like I'm supposed to do it. It said, where do you want to go? Where do you want to redirect? You select it, and then you hit save, and it's supposed to redirect.
Right.
Not. Yo. Bro. Oh, you'll stick around now that you got junk food?
Yeah. That's what I figured. As long as we got the spice and we got some junk food, I'm pretty much okay.
Okay. So we're going to go in order. You're going to need to give me a hot minute because I got to switch program. I got to switch everything. I got it in biggin. I got to tell it fit to width. Oh, it's upside down. Let me embiggen. Let me share screen. I have to do all this cray things. Okay.
Hi, Melanie.
And then I got to figure out how to embiggen this. And there we go.
Out and about.
What?
How is this? That's too
I
loud.
can't hear your what? You need to turn your mic up. I can't hear you.
Out and about with Diane. Can you hear me now? Can you hear me now?
I can hear you better.
Can you hear me now?
Yep.
Great.
Thank you.
Is that too loud? Not loud enough? Too great?
I don't know. You need to ask others.
Okay.
Sorry.
Okay, thank you. Let me know if I need to change things, guys. I appreciate it. We appreciate things. You guys letting us know.
I'm having to skirt things around you guys because I have to embiggen this for everybody. And it to wit. Can y'all read that? See if I go full screen, it doesn't do it.
Yeah. Okay, now I can read it.
Wait a minute. How did they do it? What did they put their stuff in? Like EDB and other people. I know they have Macs, but this is driving me freaking nuts.
That's good. Right there.
Oh, let's just do fit to page. There we go. Okay. I want it bigger for me.
Yeah, that sucks.
Okay. I'm going to get this microphone right up here. Y'all hearing me well? Okay.
Mhm.
Come now. Wait a minute. Wait a minute. Gotta do it. Come now, the court, to give notice that the attached email was received in the court's assigned divisional email account this day, August of 2024. Okay. Now, this email is a little weird to read, so you guys need to be a little patient with me, okay? Because whoever wrote this doesn't know how to write English. They don't even know how to spell the word Y-O-U and capitalize it like I.
Like
So
periods in
I
there.
don't know who is doing this, but this is where we are.
They don't like
Dear Judge,
sentences.
my name is Adam. I've been trying to contact you for many months. I hope this finds you well. This is Ref Ashley Benefield, didn't even capitalize it. Murder trial, not capitalized, have some details that may help you in the case. I would if come forward soon, but I didn't know the trial was happening or that Ashley had acted out her plans.
Yeah, this is hard.
What?
I'm so
Oh my gosh. What? Did you hear that? Can you hear
so
that?
we have another gentleman. Oh yeah.
I had
Yeah,
no
yeah.
record scratch. Yeah, it's the
Oh
same.
yeah.
I'm putting it before everybody so they can kind of get the gist of this. In 2018-19, me and Ashley spoke on Facebook and Facebook Messenger. I had messaged Ashley and we had long chat back and forth for many months, getting to know each other. We shared our lives up and downs. Ash had shared many things with me, and she expressed many times that she was unhappy and that she had fears that he, meaning Doug, was going to take her baby away from her and that she would be alone and have nothing. She shared with me that he kept following them and saying in his car, watching them. She said he was scared, and she said she was scared and worried that he may do something to harm her. Said, had she done anything to hurt Ashley? In the past, she said, yes, I didn't know anything about guns or that she was going to carry out the murder. However, she had asked me to harm Doug and that she would be safe and that she also said that we could be together. I stated, no way, that's crazy. What is he really doing to you for you to want him to harm him? She always kept changing the subject around into me, and at the time, she stated to me she had over $1 million in life insurance and and also army benefits that she would get each month. I do not know if this is true. Hey, Lisa Vogel. All of y'all. Hello. I'm all like,
No.
oh my.
Oh my God.
Is that loud or is it Good level.
That one is a bit loud. That specific one.
We'll go through the sounds one day.
Yeah.
They're all different.
We'll hop in here later or something.
Ooh, we spoke for some months after the question. She kept on and on about doing this. She also said that she was do things around the house to make it look like he was doing things to harm her, but I fact he did nothing. We spoke about moving guns around, talking a little, taking a little trip so she could come up with planting things or also coming up with opportunities to end his life. She also sent me photos of the house and other details. Details. She also hated her older child. She stated she fought about little things and that Doug always stuck up for the other child. What? That is what I would call a code red. Where was this during trial? Oh my gosh.
Yeah, like did this guy take so long?
Well, he couldn't get a hold of the judge, and based on his writing, I can understand why. No offense, not being mean, but come on. Look at his writing.
Okay, so fair point. Fair point. And you know what? He was trying his best.
Well, he's trying to do the right thing now.
Yeah, and he is trying his best to get his story out. So
Yep.
well done to him. So, you know.
Who she was very flirtatious. Well, he got that right, and desperate to maintain contact. However, I didn't want to be a part of this. She kept messaging me, calling me on Facebook. I gave us permission to look at the chats between us. So I give permission. So he's giving them consent to basically, hey, subpoena my chats, y'all. I'm giving permission. I'm in fear of coming forward and being involved with her again and being out on national TV. She scares me a lot. What?
That is fair. But I think Facebook is one of the people that it's like the hardest to get a subpoena from them in certain countries. So if he's saying like have at it, then I guess they're getting access to those records, and if there's something there, then they might have access to some more of her Facebook records or some more of her social media. Like, I don't know what. Wow. Whoa.
I mean, this is heavy.
Yeah.
I mean, that would have been if this is remotely true and he had any kind of text where she talked about the decedent and the possibility of the decedent situation, this would be the end of that.
This would be complete nail in the coffin. No parole, maybe. Like, that is something. Because he's basically saying she manipulated me, and Doug was not doing what she said, and she wanted to go and plant things in his house in order to, make it so that she could get her child, and she wanted to go on trips in order to do certain things. And so for him to say, and for him especially, and I'm not saying this in like a poor way, I'm just saying for him to come up with such a succinct sentence about how she has been like manipulating me to try and perform this. It was right at the end of the letter. It was, even though he was kind of having trouble getting all of it out, he right at the end was just like, she was trying to manipulate me into killing her husband. And it was just like, bam. He saw it very clearly for what it was. And he says, I am very, very scared for whatever is going to happen with this,
Yeah.
because I don't want my life to be a circus.
His writing is so atrocious. I could understand why he struggled, if he did, to try to get a hold of people. But yeah, this isn't good. So maybe
But
if he didn't
fine,
write,
go back and
think that they
read that
did.
last
Where's Braxton?
Braxton is sleeping. He's sleepy.
Well, he didn't think she was guilty because he
Oh,
was.
yeah. Man, when Braxton wakes up for his night shift, we are going to have to talk to him. Well, I'll be awake still, so I'll be like, oh, Ada's got some documents. So who I think she's done that to several others, and he's the only one that's come forward so far. But that if he's the one who's going to break the seal, that there's going to be other people who will come forward. Because if she was so brazen to do that.
Better. This is driving me absolutely. Oh, I got to do that. I have to make it smaller on my screen to make it fit this screen.
Mm-hmm.
Go figure. See, I can't. I can do this and slide that over. Do this. I want to be able to get it like everybody else can, and I can't. In the circuit court, okay, State of Florida plaintiffs versus Ashley Benefield. Transcript of excerpts of the stenography report. What? Stenography, whatever, reported proceedings held before the Honorable Judge Matt Wyatt, Circuit Judge, July 30th of 24. Miss O'Connell, oh, we got voices. Miss O'Donnell. Judge, I would like you to remind the defendant at this point, I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that. The court, do you request a PSI? Taylor, I think we'd prefer to have the PSI. Court, I will sign an order tonight for that. It's late evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating and a sentencing hearing. If you let her know how much time you need. Right now, the present investigations are running a month to 6 weeks. So it will certainly, the time for sentencing will be outside of that. But if you can let me know how much time you'll need. Taylor, let me direct myself, Your Honor, to the post-trial release if I can. Yes, sir. Taylor, under Youngston, I know that the court is familiar with the standard. They state in no uncertain terms, but if taken in good faith, the grounds not favorable but fairly debatable in view of the decisions of the Supreme Court when the petitioner should be admitted bail. And they set out for the trial court 3 factors. The first, with representation to the appeal not being frivolous, I think the court's own acknowledgement at 2 different points in the trial, I was all like, what? You didn't just smack the court. He did. Different points at the trial, the court noted that we're dealing with a novel issue and that the court had not seen before. I think it certainly have good faith and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as a respect for the law. Ms. Benefield has no prior history of criminal activity. As the court knows, her local attachments to the community, by the way, of family ties, business, and investments. She lives here in Brandenton, has lived here for a while. Her mother resides here as her child resides here. The sentencing was scheduled for October. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. any other circumstances relevant to the question or whether the person should be tempted to remove herself from the jurisdiction of the court. Miss Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she is on. As a result, we ask the court to entertain setting of a post-trial bond. The only other thing that the court noted in the Young Hens decision is that it's axiomatic that the exercise of judicial jurisdiction should never be arbitrary, whoa, or unreasonable, and where the discretion is exercised in favor of denying to the person the basic fundamental rights. The reason for doing so should be sound and they should be clearly stated. In pursuant of Rule 3.691, the post-trial release, Your Honor, we ask that the court admits Mrs. Benefield to bond continue on the same bond in fact. And if the court is not inclined to do so, we ask Your Honor to say the decision so we can appeal directly to the second district. Meaning, if we don't get what we want you to spell it out clearly. So we know what to put in our document that we probably already pre-written and just need to plug in the holes. As the court knows, it's accelerated docket because of the nature of the motion that is to set bond. Court, thank you. State, did you want to be heard? Miss O'Donnell, Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared on every trial court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny bond. Court, any rebuttal? No, sir. Court, Ms. Benefield, the jury having found you guilty of manslaughter with the firearm, I'm going to remand you to the custody of the Manatee County Sheriff. You will revoke your bonds where you will be held pending sentencing. The court will stand in recess until we get a sentencing hearing set up. Mr. Friel. Thank you, Your Honor, Ms. O'Neill. Thank you, Your Honor, Ms. Taylor. I trust Your Honor will issue a written order to that on the bond. Court, the bond? Taylor, yes. The court, yes, if it's required, I certainly will. Proceedings were adjourned. Okay. Exhibiting number 1. Okay, it's the same thing we just read. Okay, a motion for new trial. Oh, this ought to be good. What do y'all think?
Hot dang. State of Florida versus Ashley Benefield. Oh. Well, this is some spice. This is good. This is fit a little differently. I'm trying to get it in big into as much as I can. Oh God, 26 pages, y'all. We're not going through all of it. All right. Ashley Benefield, through undersigned counsel and pursuant to the 6th Amendment and the Due Process Clause in the 14th Amendment of the United States Constitution and Article 1, Section 9 and 16, the Florida Constitution, as well as Rule 3.600A, 2B, 2, 4, 5, 8 in the Florida of Rules of Criminal Procedure, hereby moves the court for a new trial. As grounds in support of this motion, Ms. Benefield alleges the following. Hi, Zach. Well, thank you. When are you going to come here and say hi to you in person? I'm waiting. Give me a little heads up. Nothing by. Yeah.
Prosecutorial misconduct. prosecutorial improper and inflammatory remarks during closing arguments prejudices Ms. Benefield's suggestive rights to warrant a new trial. Legal standard under Rule 3, period 600, quote B, in the Florida Rules of Criminal Procedure, the court shall grant a new trial if 5. The prosecutor was guilty of misconduct, or 8. For any other cause not due to the defendant's fault, the defendant did not receive a fair, impartial trial. Rule 3.600B5 requires that the court grant a new trial where the prosecutor is guilty of misconduct, prejudice, is prejudiced, right? The defendant's
Prejudice, yeah.
rights, huh?
Yep.
Oh my gosh, let me see. Out and about with Diane. Hey, how are y'all? Misconduct. I know it's a laughing stock. Misconduct. My buns. There's no misconduct here. I don't know why anybody think that there was misconduct in this. It to me is insane, and this is what I think about it. So,
Can they introduce the letter if she gets a new trial? Can they introduce the letter that you just read? Do you know? The state, I think, can't they?
Yeah, they need to be careful. I have you over on my side screen so I can read this. So if I'm eyeballing the side, please forgive me, guys. Okay. Defendant sub rights. Improper prosecutorial comments warrant a new trial where they deprive the defendant of a fair, impartial trial and materially contribute to the conviction, are so harmful and fundamentally tainted as to require a new trial, or as so inflammatory that they may have influenced the jury to reach more severe verdict than it would have otherwise. Spencer versus State, 645 SO 2D 377, 380, Florida, 1994. The defendant's subjective rights are prejudiced if there is a reasonable probability, but for the remarks, the outcome would have been different. So they're saying that the judge made comments in front of the jury that made them biased. Do y'all remember that? I sure in the hell don't.
Well, I hope they're going to thrill us with these comments.
Oh, they are. False statements about Douglas Benefield filing for sole custody. Oh, they aren't. They just skipped to number B. Letter B. Number B. Oh my gosh. Now I'm thinking about
That's
Apple.
a bit of a surprise. Okay. Well, B.
During closing arguments, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated on May 4th, only a few days later, after she filed for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, and that this man is going to get sole custody, but she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it is probably not safe for the child to even be with her, so he files for full custody. The statement was entirely false and unsupported by any evidence presented in trial. In fact, the court docket shows that it was Ashley Benefield who filed a motion on May 4th, not Douglas Benefield, Exhibit B. The prosecutor further emphasized the false claim that her PowerPoint presentation displayed the jury. She displayed it to the jury. Ooh. Douglas finds out, okay, on 9/2019, Douglas finds out she's dating someone else. Douglas files for a divorce. Series of complaints start. 5, no charges. 5/1/20, defendant files for another injunction. 5/4, Doug files for sole custody. Here's where they're having a problem. See multiple therapists. Forrest Quintal, defendant acts different in front of Doug. Social outings, beach, movies, restaurants, and pool. 6/1 of 2020, sent for eval. Dr. Broder. The improper argument implies that the state had informed but not presented at trial, suggesting Miss Benefield was going to lose custody of her child. The final motive put forward by the state. Such comments referring to the matters outside of record are clearly improper, as she held in blah, blah, blah. A prosecutor may not refer to facts in evidence as it constitutes a form of unsworn testimony not subject to cross examination. He's got a point. The appellate courts held that it was improper for the prosecutor to refer to any testimony or items not in evidence. I'd have to go back and watch some of that. Given the highly presidential. That's right, Haley Mouse. They could have objected at the time. And if you don't object, too bad. It's like if you don't document it, it didn't happen. Given highly prejudicial nature of this false claim about Mr. Benefield seeking sole custody, there is a reasonable probability it affected the outcome of the trial. Moreover, improper comments deprived Miss Benefield a fair and impartial trial, materially contributing to the conviction, and were harmful and fundamentally tainted, as well as require a new trial. Miss O'Donnell's statement exceeded all acceptable bonds of advocacy, and deprives Miss Benefield of a fair, impartial trial. A new trial is warranted on the grounds of this alone.
Do you remember them belittling her?
I sworn this was brought up in trial. They didn't.
I thought it was dealt with.
Now.
Yeah.
Improper Atkins on belittling of Miss Benefield's character, and I attack y'all. I've been doing this all day. Improper attacks and belittling of Miss Benefield's character and identity. Well, kind of, sort of. That's what you get when you go in and do this kind of stuff, right? The prosecutor repeatedly and improperly attacked Mrs. Benefield's character, calling her a manipulator at least 14 times during the closing argument, and claims that she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. What is that?
Such vituperative. Whoa, that is a word. I learned a new word today. People, let's figure out what that means.
Go place.
Sorry guys, we're gonna learn a new word because I don't even know how to say that.
Sour grapes, exactly. There is one time I felt that the lady kind of went too far with her. But do you know what? It is their job to push. It is their job to invoke when they're on cross. And if they did that and then felt that they needed to bring that up again during closing, so be it. For example, prosecutor Suzanne O'Donnell O'Donnell told the jury. Oh, I got it.
Vituperative means bitter and abusive.
The defendant is trying to say he was in fighting stance. He lunged at me. That is just her once again trying to manipulate the system. She's trying to manipulate you to believe that this was necessary. He is coming at me, but the physical evidence doesn't bear that out. It does not show that he was coming at her and that she had to shoot him.
During the state's rebuttal closing, Assistant State Attorney Rebecca Friel told the jury the house buying the house. I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that, they were talking while they had this mutual injunction. They were, I'm sure. Miss Benefield was lying to him, telling him they're going to move into Maryland, live in separate houses. But co-parent, emphasis added, co-parent. And she was all the while planning with her attorney to have an injunction hearing in the matter of days. It's reasonable to believe that the mutual injunction was, I'm sure Miss Benefield was speaking to him when it was convenient for her. She could have, when she could get something out of it, it only goes with the rest of it, emphasis added. This letter we've heard about, and Miss Benefield testified to about all of these things. It's another effort at manipulation. We do not know when she wrote that letter. We do not know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm Queen of England, rest her soul. It does not make it true. And just because I wrote it 3 years ago doesn't mean I didn't. I keep saying manipulation, and the reason is because the defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about in Dr. Lewis and Dr. Mr. Hag? They talked about the defendant. She told him what she says happened, right? I don't even think she told them the same story she told you based on what they said. And they need to fix their grammatical errors as well. I would submit to you that those two experts, Mr. Hag was the one you should be depending on, even though he also spoke to Mr. Benefield so clearly, got one side of the story or made up story. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. He's concerned. Her concern was not that Doug was going to fly off the handle. She said she was concerned that she would make him look bad in front of Dr. Broder. I guess it's Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was an abusive, horrible man, they have defamed him up and down. No, she didn't say that. She didn't say I was afraid to Doug. Doug would freak out on me and I was afraid he was doing this. So she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. Okay, do we need to read all that? Oh, how much more do we need to read on that? Just because she didn't do it means it isn't true. And that's because I said she tried to manipulate the system. She tried to manipulate the system in Florida. She tried to manipulate the experts. I already told and talked, and I think in some cases she did try to manipulate you. These inflammatory attacks on Mrs. Benefield's character served no purpose but to inflame the minds of a jury against her. Such arguments were clearly prohibited. Let me get through this. She permitting this general attack on the defendant's character was error. The prosecution also ridicules Miss Benefield's testimony, with Miss Friels stating, Cat Mandy, hey, y'all. How y'all doing? They probably can't introduce the email in a new trial. It's hearsay. Well, she directly asked him to help in the life of her husband. Yeah, they would have to bring him in to testify under oath. Without that, it would be hearsay. But what they could do is use that to try to get a retrial. What couldn't they? I wish we could get a hold of Jedi Jess. You can decide what you think about her testimony. She's a witness like any other, and that is true. But I would submit to you, that was all manipulation. There were no tears. You use your common sense. If you cry and you have to take breaks and you're racking, then you're going to have swollen face. Oh, that. You're going to have a swollen face. You're going to have, your eyes are going to be puffy, and you're going to have snot. Oh my God, I laughed. Later. I laughed so hard right here. I mean, she was all but demonstrating it. You're going to have snot coming you're going to have snot. I don't know what other word to use. She had tissue until I can't remember who, either the judge or the defense off attorney told her, "Hey, there's tissue." Oh yeah, I should. Then she cried for 15 minutes and didn't even use the tissue. That's manipulation. That's her effort to manipulate you and make you believe she was a victim. She's not a victim. Douglas Benefield was the victim in this case.
Yeah, those Kleenexes were dry. Those tissues were
Okay,
dry.
now I did go and watch the body expert people and that kind of stuff, and they were all saying that was all of that was a play. All of the body experts were calling that an acting job.
Oh man, here's the word again. Do you want me to say it?
Vituperative. Vituperative.
Yeah.
Vituperative. In Texas, we gonna call such a vituperative characterization of a defendant armed proper and prejudicial. As stated in Gore vs. State in 1719, 719 SO2D 1197-1201, Florida 1998. Are you enjoying this?
You know what? I'm reading some of it. We learned a new word, honestly. So we learned how to say it. We learned kind of what it means, even though I will never really use it in my life. Because why am I going to say vituperative?
Well, I kind of stand with you there a little bit, Kate Mandy. I go ahead and pop her back up for a second. The top one, 737. I don't believe really that the case was thoroughly proven by the defense. I think they both left a lot to be and a lot lacking. But do I believe that she did this? I believe she did. I don't believe his actions warranted being shot down all the way. I don't, there are some actions that deserve, there are real threats that are made that you can definitely defend yourself. But anyway, we'll keep going. A prosecutor cannot engage in a
Vituperative, yeah.
The vituperative or
pejorative. Why are they doing this today?
regular, or in other words, needless sarcasm. Oh, like right now, revealing that the prosecutor had abandoned any semblance of professionalism. I think we got tired of all your bullshit. In the words of one viewer, the prosecutor sounds like a couple of high school bullies. Well, I guess you may know.
This person is using really big words because they don't have like the greatest argument. So if you think that the judge sounds like a high school bully, then really you sound like the straight A student that really bothered everyone and got all the scholarships, but like pushed it in everyone's faces.
Still not enough. The prosecutors want even further. The prosecutors went even further and claimed Ms. Benefield was lying with no evidentiary support. They said that she told defense experts a made-up story, again without any basis in the evidence. Such attacks on the defendant's credibility are improper. As the court cautioned in blank case, where the case against the defendant is weak or tenuous, the prosecutors contentions and the defendant is a liar could rarely, if ever, be construed as harmless error. The court held that the improper prosecutorial comments will warrant a new trial where the evidence is very close, where the prosecutor refers to testimony or items not in evidence, or where a prosecutor indulges in personal attacks upon the accused, her defense, and her counsel. Okay, we're going to start skimming because we're only on page 7.
Oh, yeah. Yeah, for sure. Please do, Ada. I'm sorry.
speculation about out of court conversations. The prosecutor feel engaged in proper speculations about conversation between Benefield and Douglas, stating, first of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that, they were talking while that they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they were going to move out to Maryland, live in a separate house, but co-parent.
Hi, darling Deb. Thanks for joining us.
Yes, thank you. They're saying there was no evidence presented in the trial that they were communicating with while the mutual injunction was like bullcrap. She even said they were. False claims about defense expert testimony. Dr. Lewis, a medical examiner, seems like a well qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you why would she do that? She did that because she was getting paid to be here. That's why she's here. That's why she's saying those things. And most of them were probably very accurate. Improper appeal to emotion and sympathy. After she runs to the neighbor's house not once do you ever hear her say, "Get an ambulance." I don't know if he's still alive. I had to do it because somebody helped him. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. And she was the only person armed in the room. Doug Benefield was not armed. So I don't understand this because the facts are the facts. She admitted to shooting him. That is not under contention for this trial. Improper burden shifting. The prosecutor repeatedly misstated the law on self-defense, telling jurors they need to evaluate whether Miss Benefield's use of force was reasonable and necessary. Okay, that's small enough. So, real question in this case is that their self-defense was their justifiable self-defense, and was the self-defense instruction is long, and you have to have it to review in the back. However, what you will notice is that two words will come up all the time in that instruction: self-defense. Justifiable use of a deadly force would be. Ashley Benefield was justified in using a deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or forcible felony. You're going to see those two words. Like I told you a little bit earlier, that what you need to think each time that you're trying to evaluate whether she used force appropriately. And that's not a lie. That's accurate. She's reading it straight from the book. So she shifted the weight of burden by constantly saying reasonably and necessary. Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm or forcible felony. And that's written in the law. Why are you then you have to decide, was she justified in using self-defense? It was reasonable and necessary based on what happened in the house, that she shoot and kill him on September. Well, I don't understand why they're arguing that. False representation of wound path.
Okay.
About the trajectory, just because there's a sort of some misconception that this shot was front to back, and that is just the plane with which the medical examiner used, so it could be a little confusing. But if you look at the way the arrow is in, the bullet goes in right by the right nip and then lands right here. So the side to side, now once it went in there, the nip did it curve a little bit to the back? Yes, that's why it's like in the back. That's why they said front to back. So it went from side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from front to back. So if it went on the side right here. Okay, I had a question about that, but I will say this. Get my trusty little thing that I've dropped both of them. This is a body. This is your side, front, back. Front to back can be this.
Mhm.
Back to front can be this, right? Back to front can be this, but on an angle. If the entry wound here and exit wound is anywhere, even if it hits here and say it comes in like this, so it goes in on this side underneath the rib cage and exit in the armpit on this side, which means it's this kind of an angle. It is, and I'm shooting from an angle, it's still a back to front. Or if you turn the person around, you can do front to back. But they're trying to say that they lied. Even a sideways, it could go in on the side, right? It can go in on the side. But if it hits the spine, which it did, it can deviate it to the front.
I don't think that they're making a great argument, even though they have a good, because it's not necessarily the trajectory of the bullet that is the problem. It's that they could argue he was turning to the side and going to walk away from her. And that's how he got kind of shot on the side. I think they're kind of focusing maybe on the wrong.
Mm-hmm.
So that's an odd one, because you're right. It's a front to back, and it's pretty much like diagonal through the body, but it's front to back still, because it went in through the front of the rib cage.
It came out back behind the bullet. Yep,
yeah, pretty much.
In an even more blatant misrepresentation, Miss O'Donnell used a graphic depiction to demonstrate what the wound path entered and the decedent's right side behind his right arm, transversed his chest and a straight path and lodged in his back. This was a flat out misrepresentation and uncontroverted testimony which clearly misled the jury. Cumulative effect. Okay, so they're just going to say all of this stuff put together gives us the right to appeal.
Yes, we all love Jules. Jules is the best.
Juror number 15 failed to disclose on her questionnaire material information and further concealed material information during the voir dire that would have resulted in at minimum, a challenge by the defense. I'm getting tired. Legal standard. A juror who conceals material fact that is relevant to the controversy of guilt of misconduct and the misconduct prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. So they're saying that they had a juror that didn't fill out the form right, therefore they're wanting more, they want it dismissed. Concealed information was relevant to concealed juror the case, the Florida Supreme relevance. I want to know what it is. Failed to disclose well-concealed fact one, that she was a victim of domestic battery in February of 2016 when her live-in boyfriend initially slapped her in the face with an open hand 5 times. Her son was charged with felony battery against his pregnant girlfriend. Juror 15 was a bond visitor in the case. She was responded to multiple petitions for injunction for protection against domestic violence. Okay, that could be a problem. However, it also depends how long ago. And some of these questionnaires sometimes have a time frame. But if she didn't disclose any of this, that could be a problem.
Yeah.
West Coast, I don't want to give these people's names. I think that's not fair. That's more on that person. I'm going to scoot. Concealed. I'm going to scoot
Chapman,
past that.
I do think the prosecutors did say some not some improper comments, but Taylor should have objected. You're right. And Lacey, welcome. Thanks for joining us.
Oh, wait, I do think the prosecutor said a lot of improper things during. Yeah, I do.
Mm-hmm.
But once again, here's the thing: closing is not evidence; it's their opinion. There are limits, but it's not binding evidence. So, unidentifiable juror misconduct. Last year, though not yet traceable, unidentifiable juror upon information belief that known that brought a cell phone into the jury room and used it during deliberations, consisting of objective act of compromise integrity. Wow, now that's an issue. During deliberation, juror brought a cell phone into the jury room and used it while discussing the case with other jurors. Direct violation. Florida law. During the jury deliberations, a YouTuber used that hoodie guy posted comments on the Law and Crime Network YouTube stream that in the verdict watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of court. What? Now that can be okay. Here it goes. Now this we're gonna look into this. 10:20 p.m., 10 minutes before the parties were notified that the verdict had been reached. That moment saying, verdict incoming. Oh, would that be Turtle Boy?
I'm not sure.
At 10:25, that hoodie guy posted a comment saying, per sources 5-1 guilty with the man stuck on not guilty or manslaughter. 10:27, the hoodie guy pulled sister snuck a phone in. Okay, now this is serious. This is where we have serious problems. At 10:28, the hoodie guy posted saying, I'm the brother of one of the jurors. She just texted me, per source 5-1 guilty with the man stuck on not guilty or manslaughter. The hoodie guy posted a comment at 10:28. My sister snuck a flip phone in. She texted ME 5-1. Okay. At 10:30, a mere 2 minutes after that hoodie guy, the jury may have compromised on manslaughter. The jury returned compromised verdict on manslaughter. The timing and specifically of these comments following the correspondence jury action strongly suggests that the hoodie guy information, or can you look up who that is, please? That hoodie guy originated from within the jury room during the active deliberations. According to Ms. Benefield, has formally requested the court to interview the jurors in the presence of the parties. Now, that is serious. Legal standing, once been established jurors' misconduct. So there's a case here. Cell phones during deliberation constitutes juror misconduct in the presence of cell phones and misconduct. Using a smartphone access. Okay, so that way it's just giving the law on it. Okay, we made it all the way through. Oh, Lord, have mercy. Help me here. We've already seen this.
I'm just looking at the hooded guy, or the hoodie guy, sorry. It's the hoodie guy channel on YouTube. And I'm not exactly sure what his content is about because it looks to be about all sorts of different things. About chess.
I love you guys, but this is another 20 pages.
Yeah, if you want to tap out, then that's all good.
Well, no, I'm going to leave this possibly for tomorrow. I think this is kind of hitting some of the things.
Well, and I can look up who this guy is and then try and get a little bit of context before
I'm going to go straight to this because
tomorrow.
wait, the other
Hi,
thing.
Jar. I'm sorry, I didn't notice you were here. My headphones went dead, so I had to grab some more.
Okay, welcome, Mashrio. I'm Japan. Welcome,
Mashiro, Japan.
Deb.
Hi.
Welcome. Certificate of service. Please don't. Oh gosh, 26 more pages. Motion for trial. Request to interview jurors. Incorporated memorandum. Misconduct. Legal standards. False statement about Judge Benefield filing. So custody. We've already been through that. What I'm looking for is motion to interview jurors. That's what I want. Oh, didn't mean to do that, but I got it. Motion to interview jurors. Okay. Ashley Benefield through the undersigned counsel in pursuant of the Rule 3.575 in the Florida Rules of Criminal Procedure in conjunction with and as a part of her motion for new trial hereby moves the court to conduct interviews of the jurors in the incident matter. On July 30, 2024, the jury rendered its verdict. Evidence had come to light indicating that the verdict may have been subject to legal challenge due to juror misconduct. And then it goes again talking about the hoodie guy, comments, the dates, the times, and what was said, and the timing. Okay, this allegation misconduct raises serious concerns integrity of the jury. Yep. The juror smuggled an electronic device into deliberation. Yep. Real-time communication of confidential jury deliberations with non-jury members. That's bad. Influence external to the evidence presented during the trial may have influenced the verdict. Access to unauthorized material affecting the verdict. The overall integrity of fact-finding process being compromised. The prompt removal of these comments from the verdict watch on the Law and Crime Network YouTube channel live stream further underscores the seriousness of the potential juror misconduct. In addition to the above, the evidence has come to light indicating that the verdict may have been subject to legal challenge due to juror number 15 being untruthful during the voir dire and falsely representing what she had not been a victim of crime. So, and the situation with her son. I'm not going to read all that with juror number 15. It continues. Juror number 15 continues.
Thank you very much. That the hoodie guy apparently posted verdict info before the lawyers did in comments on YouTube. So
he did
for that context.
I don't want to talk about juror 15 until they actually have that resolved because I don't feel like I don't want to put all of that information out there for someone to come in and
Ronnie, I'm not sure if the hoodie guy could be a juror. I don't think he could be because
his sister was the juror.
Oh, his sister. Thank you.
The sister was texting him information from the jury room.
Sorry, my headphones.
Last one. Circuit Court, 25th Judicial Court, and the Manatee County State versus Ashley Benefield. Ashley Benefield motion to disqualify the Honorable Stephen M. Wyatt supporting affidavits and incorporated memorandum of law basis. The court conducted an open court immediately prior to commencement of trial on the 22nd and at the July 30th, 24 verdict promptly prejudiced the defendant. Specifically, the court's, I got to make it big, and that's why I'm struggling. Declination to voluntarily step aside declination to voluntarily step aside, as well as the court's arbitrary and capricious, oh my gosh, refusal to so much as even acknowledge Mrs. Benefield's request for post-trial bail created separate apprehension from Miss Benefield that she reasonably fears she will not be receive a fair hearing or sentencing because the court's personal bias and prejudice against her. No previous disqualification motion has been filed in this case, and the transcript of the post-verdict bond request is attached. The actions taken by the court, i.e., in complete refusal to even acknowledge the defendant's motion, yet alone entertain, evaluate, rule on it, plainly appears to the defendant that the court never intended to consider it and remand was only option given the court's consistent display of prejudice against Benefield and in favor of the state throughout the trial. Guys, the judge can listen to all of the suggestions. He could sit there all night long and listen to 50 people give their opinion on whether or not she can be out and free or behind bars. In the end, he's the one that makes the decision, and he probably already had his mind made up. Probably already had a zero. Oh, okay.
Masiro. Okay. I was
Masiro.
just about to say that. Masiro, are we saying that correctly? Thank you very much for letting us know.
We really appreciate you joining us. So, my thing on this is that it's the judge's discretion. He listens politely, and sometimes some things are said that can change the mind of the judge. That can happen, but it's not required. The judge is looking at this from a full spectrum, both with the victims, the family, the citizens, the risk to, it's not just a little itty bitty thing. Memorandum. It is established in the law of the state that every litigant and is entitled to nothing less than the continuity of an impartial judge. I don't think he was not impartial. Oh no, they're referencing the SYG hearing. Considering the totality of complaint and the substantial evidence admitted during the SYG hearing, the state has proven by clear, convincing evidence that the victim's homicide was not singular act of necessary. Oh my gosh, we're not going there. Office impartiality. Under Section E, disqualification states that a judge shall disqualify him or herself in a proceeding in which the judge impartially might reasonably be questioned, including but not limited to incidents where a judge has a personal bias or prejudice concerning the party if the judge, while a judge has made a public statement in the comments or appears to comment, the judge will respect to issue in the proceeding or controversy in the proceeding. Quote from the earlier, okay, this is ridiculous. I'm not going to read everything here. Given the court's standard ground order, Ms. Benefield surely has reasonable grounds to believe has prejudiced her credibility, and anything she said at trial or will say at sentencing will be ignored. But even more immediately, the purpose of post-trial release. The court's indifference and refusal to even entertain her request leaves her with a reasonable apprehension that creates in the mind of Ms. Benefield and her attorney that such efforts will never be evaluated objectively. Disqualification is required where the trial court states that it is believed that the party is guilty prior to the trial on its merits. Additionally, Ms. Benefield has now testified. Little doubt remains that the court has concluded her testimony was untruthful. Okay, guys, I'm going to say this, and I'm going to try and not sound like a witch, for the lack of a better word. Replace the B in front of it. Ashley Benefield, the moment she was found guilty, is now a criminal. And she will be treated as such. She has taken a life. She took a life. Now, for example, Remember when that guy came into my shop? Some of you weren't there. During the members only live, we had somebody come into this place of business and we didn't know they were here and they were shopping around in our little shop area, then came into the employee only section of this shop, walked all the way past my office and into my son's office. Now, had I pulled my lead shooter, which you can hear me tapping next to it,
Pew pew.
it right here, because it's nighttime and I'm back here. And that guy stormed in, and I pulled the weapon. And I told him to get down on the ground, and he refused. I tell him to get down, even with the stun gun. I have one of those too. Just anybody who's listening, you have no hope here. And you tell me that you're not going to get down and you lunge at me, and I'm fearful, which at that point I would be, because what sane person is going to be 5 feet from a lead shooter and not listen to the person holding it? He can get down. I have cuffs.
Yep.
And I will cuff him. Now, I'll stand him up and we will have a talk until the police gets here.
You have a nice little conversation.
Yeah, we're going to have a nice one. And he's going to feel something cold in his back until the cops get here. I'm not kidding.
Oh, I don't think you are. I know you're not.
If he refuses to cooperate, now if he turns and runs, I'm not going to use the lead shooter, but we will notify the police, and we do have cameras. This happened when I was on the members only live. Now, I didn't have to go through all that process because my son dealt with him and we got him out of here. But I lawfully could have very well discharged my lead shooter if he yelled and screamed and came at me and was flailing, and I am in a very confined space. I could and legally get away with it. Now, will they put me in handcuffs when they get here until they decide and try to figure out what happened? You betcha. Will I lose my lead shooter for a period of time until they do the investigation? You betcha. That's a risk I take, and I know it.
Mm-hmm.
This girl so much bad stuff has been done to me. I'd rather take that risk than be harmed again like I've been in the past, or even possibly killed. But that's a risk I take. You don't play around. She's in a bedroom with a mattress, a box, a laundry basket with the lead shooter sitting on top, and her backpack hanging on the door with the lead shooter in it. Why would you have 2 lead shooters in that room?
In very weird spots.
Hmm?
In very odd spots, especially if you have a young child.
Yeah, a 2-year-old could easily have gotten that lead shooter, and she said, "Oh no, she could get it." Bull crap. She could have got that backpack. Wasn't locked.
Yeah.
Ronnie, it's the very first members only live. Go watch it, at least through that point. And everybody said, no, let's not call the police. And everybody on here is like, call the freaking police.
Yeah, so for anyone who's interested, we do have memberships now, and you get to be part of our members only lives that are the first Saturday of every month, I believe. And we had the police show up to our last one because of the stuff that Ada's speaking about right now. So, we like to have fun. So
do this.
We're one of the most fun memberships.
I'm going to run this so we get a little breather. We'll be right back. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. Kat, you're right. The only thing I think could be reverse, reversible errors. The judge should not allow Taylor to cross Stephanie Murphy about Doug's deposition and not allow the DNA evidence in. Well, it depends. Why did he not allow it in? There has to be just cause for him to do that. I don't think he's going to do that without having a little bit of just cause.
I believe Stephanie
I
Murphy.
think I've seen this guy, hoodie guy. Let me pull it up. Ah, he has 301 subscribers, 59 videos, and 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 he got
He got name checked in a lawsuit.
oh.
So we just need to go and say really inflammatory things on law and crime, and then we'll have all the members.
No. I've seen one of his things. I don't want to be name dropped that way. Nope.
Oh, okay. Yes, he is a YouTube guy. I'll go get his sister. Apparently was on the jury, and he apparently communicated some things that he should not have online crimes comment section, which is special.
Was in the jury room while they were deliberating. Allegedly.
Allegedly. Until we figure this out. And if Darling Deb, sorry.
No, go ahead.
If Darling Deb is still here, I just wanted to say we do have Jules on a lot because we really appreciate her input, and she's a very good friend of Ada's, so she does like to come on here and tell us her opinion and tell us, just kind of some of the things that she finds out. So if you are ever wanting to see Jules, we do have previous videos with Jules, and you can kind of catch some of those if you want to watch them, but you might find Jules around here as well.
Yes, you will. Darling Deb, honestly, what's the age group of the jurors? They were mature jurors.
Mm-hmm.
And so I would want to know, they were all pretty mature. So I don't know if he's lying and it's just a bunch of hype to get his channel noticed, which it very well could have been. That could have been all a setup. Who knows? People do crazy stuff on YouTube to try to get people to draw. Like me, I do sign language.
Yeah. I hang out with people who do sign language, and I don't sign. So that's probably pretty crazy.
Well, everybody, you guys are all fabulous, and we have had a long day. I started living at 9-ish my time, I think.
Yeah.
We're on with you.
Started very early.
Yeah. And it is almost 9:00 now. I'm warming up because I'm going to have a fundraising thing for my friend Tracy, who's got stage 4 uncurable metastatic terminal cancer. And she's my sister in love. And probably in September. And I really want to try and go at least 18 hours, if not 24. So I'm really going to start getting these long ones in to get practice. It's 11 a.m. here. I've got to get some work done. Oh, bless your heart.
Thank you for hanging.
Thank you. About with Diane and ADHD Jelly Bean Law Nerd. Oh, we need to do some Sarah stuff soon, though.
Sarah stuff. We think Sarah is an enigma. Well,
we're going to be, what we did not finish today, we're going to do tomorrow during lunch break, or if more stuff hits, tomorrow morning. Now, we are starting at 9:30 their time, 11:30 my time. So I will possibly, I'm not going to make the decision till tomorrow morning, pop on at 10 to finish up the stuff with Sarah Boone that we were looking at. Remember, did we finish all that?
I'm not sure. I'll have to go and look back on that video. But we'll see.
We think it's hilarious hearing that. Oh, that I cried. No, we don't. No, we
Oh
don't.
man.
So no, we didn't. Okay. So come back tomorrow at 10 o'clock. I will finish up the Sarah Boone between 10 and 11:30. We will go through
Okay.
the emotions. We will do
Yep.
all that then. I just don't have it in me to do any more tonight, guys. But if you can hop in with me live tomorrow morning at 10, I'll go ahead and set the live up. And are you going to be able to hop in?
I will try and hop in at 10. I'll try my best to hop in at 10.
That's
8 my time.
uh,
Try my best.
be up at about 6 my time. So, but yeah, do what you can. I can hold it down until then. No big time. No big deal.
Oh,
Eastern.
Diane, if you're crazy and you're hanging out at 1, we'd love to have you.
Well, you can always go back and rewatch.
Yeah.
And 88 Jelly Bean, your Eastern time, their Eastern time. So
But we're Pacific. So
8? Well, it depends on 8 o'clock their time, your time.
8 o'clock would be 11 Eastern, wouldn't it? That's 3 hours later, isn't it?
Oh, Eastern. Yeah, you're an hour. That'll be 11 o'clock Eastern.
Because I'm Pacific, so it would be 11 Eastern.
11 o'clock Eastern. Yes. Yep, 11 o'clock Eastern. Okay. So we'll be 10 o'clock Central, 8 o'clock West Coast, 10
8
Central,
o'clock Pacific, yeah.
8, 10, 11. Okay. Guys, please, 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 please get some good sleep. Like I've always say, and I'll say it again, everybody hug somebody tomorrow that's not having a good day. Give them a nice smile. I need to talk to you for a second. Give them a nice smile because you never know what hell somebody else is living through. Our lives are hard enough as it is, so be kind to somebody and be their little ray of sunshine. We'll see you tomorrow. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.